Well, hello out there, North San Diego County Realtors members. You are joining the CRMLS Top Violations Overview. This is Jeff Smetana. I'm the Director of Compliance for CRMLS, and Shirley has invited me to come on down and get on this Zoom and talk to you guys about compliance stuff. Happy to answer questions. I'm going to go over the most common violations that we see and how to avoid them, and provide you with, a bunch of other information that should be useful to you. It's 10 o'clock, and I'm going to wait about one more minute before we get going. And if you want to ask a question, this is a webinar, so I'm pretty sure you can't unmute and ask, but you can use the chat. If you're familiar with Zoom, at the bottom of your control panel is a chat button. You can open that up. And we will use the chat to get your questions, and I'll answer them as we're going through things. So again, for those of you who did not hear my initial welcome, this is Jeff Smetana. I'm the Director of Compliance for CRMLS, your multiple listing service. And this webinar today, courtesy of your North San Diego County Realtors Association, is going to cover the top violations that CRMLS sees in terms of the MLS rules, and give you some information on how to spot what's going on and to make sure that you don't, end up having to talk to compliance in an unhappy way. So it is 10:02, and I am going to get started. So hopefully you can all see my screen. Once again, if you have questions, just throw them in the chat. I'll pause here and there and see your questions, and then I'll just answer them on air. So let's get going. Again, this is CRMLS compliance-based content. Speaking of that content, if you are, enjoy this webinar, or you get good information out of it, everything I'm going to cover is available to you on crmls.org. Again, that's crmls.org. You can get to the compliance page as well through your RECore dashboard. When you log into RECore, RE Center Hub, there's a link right there. You go to compliance, and you can get to the things that we have for you on crmls.org. A full page with all of the rules, everything associated with compliance, videos, slide decks, a compliance quiz, a ton of FAQs and knowledge base articles, and the citation policy, etc. So if you feel like digging a little deeper on your own time, there's plenty out there to find and go through. Beyond that, we are going to go ahead and talk real quickly about where do these CRMLS rules and policies come from. So sometimes there's a misconception that CRMLS is its own entity and just makes up the rules as we go along. That's just not true. We are an NAR affiliated multiple listing service. So we are, our stakeholders are all NAR realtor associations. We are bound by the NAR model MLS rules. We are not bound by the CAR model rules, but we do take them under advisement. So if NAR makes something mandatory, or if it's in their model rules set, it's probably going to be in ours. If it's mandatory, it definitely will be. From there, internally, CRMLS has a rules committee, and that rules committee is made up of a representative from every AOR that we have. And all of those folks are agents and brokers. So the folks doing the day-to-day nuts and bolts kind of making and modifying the rules and the citation policy decisions are agents and brokers. So it's not the staff doing that. And then ultimately, anything that we do is approved by the CRMLS Board of Directors, who are also agents and brokers. So from start to finish, beginning with NAR's model rules, again, NAR, the MLS policy committee is made up of agents and brokers, through the CRMLS Rules Committee and all the way through our Board of Directors, it is fellow practitioners who are making the decisions on how and why we should do the things that we do here at CRMLS Compliance. Sorry. All right. I want to talk to you briefly about the citation policy. So you know that we have a rule set. The rule set is like 50-something pages long. I don't expect anybody to have a copy of that and know it very well. There's over 200 rules in there, but we only work on the citation policy. There's only about 65 rules on there that we actually enforce. And realistically, on a day-to-day basis, we probably work with 15 or 20 rules max that are actually getting inquiries and warnings and citations. The citation policy is the companion document to the rule set. The citation policy gives you a list of all of the rules that we enforce, tells you whether or not that rule is entitled to a warning before a violation occurs or a citation is issued, tells you a little bit about the rule as well as the fine associated with it. The citation policy also includes some other information about timelines and deadlines, such as if you get a citation, you need to fix what's wrong within 2 days. Also, that if you do get a citation, you have 20 calendar days to pay it or ask for a review. The citation policy also spells out in great detail what you can do if you disagree with your citation and you want to have that citation reviewed by your AOR. We have a long process for that, so you have full rights to challenge that. It can be a little bit of work, but and if you have good evidence as to why the citation should be upheld, obviously you should take advantage of that process as well. So the review process is also set forth on the citation policy. Citation policy is only 3 pages, so it's kind of a good thing to have. You can get that on our CRMLS.org page and own your own copy. So let's get into the dot violations, if I can get my mouse to behave. Okay, so what you see on the screen are essentially the most common rules that are violated. There are about 8 or 9 different particular citations that are encompassed by these rules that you see on the screen. But generally, these are the most common violations. Now, I will point out that this group of violations on the screen make up about 75 to 80% of the citations that we issue every year. It never changes. Now, the good news is these are really simple rules to follow. I see a question on there. What is auto sold? That shouldn't be on this slide. That relates to Matrix. You guys are Paragon. Don't worry about that. Ignore it. Thank you, Lori. Again, these make up about 75 to 80% of our annual citations. They're very simple. They're not the complicated ones. They're not the big, pricey violation fines either. So if we could simply get everybody on board with following what, are pretty clear-cut rules, we could cut down on the number of citations. And hopefully at the end of this webinar, you guys will be among the group who never get any of these citations. So let's get started on what's what. First thing we're going to talk about is photos, media, we call it. And when it comes to photos and media, that means photos or videos, right? Your virtual tours. There are really 2 main things that you need to keep in mind. The first one is on the screen there under, with the little X next to it, is about the content. The content. What can and cannot be included in your pictures and virtual tours. It's pretty straightforward. I'm going to tell you in detail about that. So content is key. You need to be able to look at your media, your photos and your videos, and before you upload them in the MLS and say, is this thing fine with what it includes or doesn't include? And then the second half of the photo concern is permission. So permission is very, very important because it implicates, other law outside of the MLS, such as the Federal Copyright Act. We ask, and you agree when you join CRMLS, that if you put some media into our system, you have the right to do that. You have the right, legal right, to, publish that media content. Okay? If you don't have the right, you need to get it before you put the media in your listing and let it go live. After it goes live, you have published the media, and you will definitely have a problem with us, and you may very well have a much bigger problem with the creator of that content, who you quote unquote borrowed it from, because they could theoretically sue you for copyright infringement. So again, Photos, two main things to think about is the content and the permission. All right, let's get into the content. So when it comes to content, we have a rule 11.5 that talks about, it has a long list of things that cannot be in your photos and virtual tours. So the upshot here is that your media should be neutral. Okay, it should only relate to what's being sold or offered for lease. It is not a place to advertise yourself or your brokerage. It is not a place to communicate to buyers or potential clients or other agents. It's only to show what is there. All right, what is good about this property? What's the marketing? What's going on with this? Show the public and the other agents out there what they will be coming to see if they come for a showing. Following along from that, there's a list of things that would not be allowed. Agent, broker, or brokerage names, photos, or logos. So again, you can't advertise yourself and put your own picture in there. Phone numbers, website addresses, email addresses, signs. We're going to talk about that. Messages of solicitation, images of people or other things, animals or other things not related to the listing, unless it makes sense, which I'll tell you about in a second. And you can't have links to external things, right? So if you have a video of a virtual tour and somebody clicks on that virtual tour from your listing and it takes them to a landing page, it can't have branding on there either. Right? You can't get away with it by just putting in a link and then all of a sudden the potential buyer is on your website. That's not what it's for, guys. All right, it's supposed to be neutral. One of the most common violations year in and year out is when agents forget that they have their sign in the front yard or in the window or wherever of their listing and it's visible in the photograph. That is a no-no. It does not get a warning. It's an immediate $250 citation fine. You can't do that. All right, it's very common and it's very easy to avoid. All you've got to do is before you go live with your listing, just scroll through the photo carousel that you've uploaded and make sure there's no signs visible. Okay, it's the equivalent of handing someone else's client your business card. What do I mean by that? Remember that buyer's agents are sending these listings, if they're interested, to their clients, the buyers and potential tenants out there, to get them interested, to help meet their needs. The last thing that buyer agent wants is for your sign to just all of a sudden pop up in front of their client. So we definitely want you guys to remember a very easy rule. Look at your photos before you go live and make sure that the sign isn't there. And if it is, delete it or blur it out and you will be fine. Any questions on that? I don't see anything in the chat. Now, people in photos are acceptable. It doesn't happen that often, but they're acceptable if they make sense and it's like a marketing photo. And if the people are not identifiable. So this photo you see on the screen, maybe you have a coastal property right near the beach. You want this picture of volleyball players out there at sunset. It's great. You can't tell who these people are, and it makes sense because the property is coastal and that's a feature. Okay, fine. What's not fine is something like this, right? So these people are identifiable in these photos. It doesn't mean I know who they are. It just means if someone knew them and they saw that, then they would know, right? They'd recognize them. You can't use people in your photos and you have to be very careful. That's just sloppy work, honestly. It doesn't add anything to the photos. This also calls for careful screening before you go live. Here, the photo on the left, I'm not even sure what this has to do with the property. And the photo on the right, sure, that's the kitchen, but that guy in the background, right? We don't want anybody to have this happen to him. We'll contact you on this. And again, this is totally avoidable if you just screen your photos before you go live. Animals in photos can be acceptable as well if they make sense, right? This doesn't have anything to do with whether the animals are identifiable. That's nonsense. But like if you have horse property and you have this picture of this particular corral, this pasture, and horses are there, great. right? I'm an interested buyer. That makes sense. I love it. Look at those horses having a great life. On the other hand, if you just love this horse so much that you want a feature close-up shot of it, what does that have to do with anything? Are you selling the horse too? No. Again, keep your photos neutral. Keep your advertisements and communications out of them. Make sure everything is related to the property or the features or the amenities, and you will be fine. Okay, so content in photos is pretty simple. Please avoid having your sign in your photos. If we could get everybody to do that, we'd drop 20% of our citations every year. Now let's get into that second part, permission, right? So this slide says copyright issues because that's really the underlying problem. If you use someone else's media without their permission, you have violated their copyright. Now, I'm not saying everybody who takes pictures has a copyright that they applied for and sent to the Library of Congress. Under the law, as soon as you create something, as soon as you press the button on your phone and take that photo, you now have a creative copyright. No one else can use that without your permission. Now, if you did take the photo or the video yourself, you are the creative copyright holder and you can do whatever you want with it. Okay, especially you can upload it to the MLS. On the other hand, if you use a professional photographer, which so many of you do you have the copyright? Do you have the right to use those photos? No, you do not. Right? You're going to have some kind of an agreement with your photographer, which you absolutely have to protect yourself and to put them into the MLS. Another thing that happens is people, quote unquote, borrow photos from old listings of the property. Maybe the person who had the listing before you a year and a half ago had great photos. You think the property doesn't look that different. I can save my seller a couple of bucks. Let me just borrow those. I'll right click and save on the photos in the MLS. And voila, we're immediately up and running. We don't even have to wait for a photographer. You cannot do that. You also cannot just say, I'm going to grab something off of Google. You can't say, this is a homeowners association and I want pictures of the pool and the park and the front gate. So I'm just going to go on the association's website and borrow those. That is a no-no. You didn't create that photo. Someone else did. That is the person you need to go to get permission before you use that photo in the MLS. Included in this is a very common violation, Google Street View. Google in general, Bing, Yahoo, Getty, any other third-party image site, just because it's out there on the internet doesn't mean it's free use. Everybody says, well, I can use Google stuff. No, you cannot. Okay, I can tell you as the attorney here at CRMLS, Google does not give you the right to commercially use their photos and their content. Okay, you can use them like for personal use. There's a limited right there, but no, you cannot use them in a commercial setting like the MLS. Google Street View, you're going to get caught every single time, right? And this happens when people are running behind. They can't get out there to get an exterior photo of the listing, or it's far away and they're in a hurry. And so they say, well, I'll just use this Google Street View photo of the front. That's the place, that's the house. And then I'll get a good photo later. Well, I'm telling you, every time these things get reported by other agents. They see it, they send us a violation report, and we issue a violation. You can't do that. And this is no joke. These copyright issues, these permission issues, these don't get a warning. And the citation fine amount on this is $1,500. It's big because we want to deter people from doing this because we can get sued too. Not just you, not just your broker, us. And so let's all agree that we will get permission before we use someone else's content. There is a question in the chat that's asking, is the permission obtained from the owner of the property? No, you do not need permission from the owner of the property to a certain extent. I mean, obviously you need their permission to be inside the house taking pictures. You need the permission of the person who created the content. Okay, and it has to be sufficient permission. It has to give you a sufficient amount of rights. When I say written permission, I don't mean that the photographer sends you a text and says, go ahead and use the photos, period. That's not sufficient. You need to make sure you have sufficient legal protection, and we require a certain set of rights be transferred to us when you upload your content. So what do you do to solve this permission issue? I'll show you. You want to use the CAR, Property Images Agreement form. It's called the PIA. This will get it done, right? So if you are using a photographer, have them sign this. You guys can come to terms on it. They can either give you a full assignment or a temporary license. It's not complicated. It's pretty straightforward. If you want to use a previous listing agent's photos, you reach out to them and get them to sign this. Whoever has the rights to the content is who you need the rights from. And the PIA will get it done. Sometimes people create their own forms. I would encourage you to use caution. Those things aren't always good enough. The PIA, unless you completely alter it and cross stuff out, should be fine. Questions on the permission issue? I want to point out the double watermark problem. So CRMLS, just like every other MLS, once an image goes into our system, puts a little watermark on it to show that that image is now part of our compilation. Okay, we have a copyright on it. That doesn't mean we own your original photo. It just means that in the context of a listing, the arrangement of everything, those photos in there can't be removed, right? That's part of CRMLS's intellectual rights on that compilation piece. Why is this important? Because if you borrow photos from the MLS and you re-upload them into the MLS, that photo will get watermarked again. You will have two watermarks on your photo. You will get reported and you will get a citation. That's, again, you didn't create that photo, right? It's part of someone else's copyright compilation. Now, this can happen even if you go to the former listing agent and say, hey, I want to use your photos, and they say, fine, and then you just right-click and save all the photos out of the listing. Don't do that, right? Make sure you talk to that agent and say, can you send me copies of the originals or unmarked photos? And then you can go ahead and do it. So be aware. I mean, if you're looking through listings and you see a double watermark, maybe now you'll notice it. Report that to us, because that means somebody borrowed somebody else's photos, and we don't like that. Okay, so any questions on the permission on use of media? Pretty straightforward. Remember the one ironclad rule. If you didn't take the pictures, don't use them in your listing unless you get permission from the person who did. Real clear, okay? I've got a question in here from Juan Carlos. Says, should the permission be from the first listing agent or the photographer they used? So I would go to the listing agent, because they're the ones who probably paid the photographer and have gotten rights from the photographer, right? So if you go to the listing agent, you're probably going to be fine. I have seen cases where they're really rare, where the listing agent had no right to use the photos to begin with and the photographer got upset. If you really want to cover your bases, ask the listing agent whether or not the photographer is okay with it. Right, but generally speaking, a listing agent is going to put them in. Presumably, they've got the permissions from the photographer they use. Okay. All right. The last photo issue is the one photograph rule, the exterior photo rule. This is very simple. Now, guys, this rule is the most violated rule. Okay, pretty much every year running. It's a mystery to me because it's pretty simple in this day and age to get at least one photo of the exterior of the structure with these great phones we have. And to get it up, you can even upload it mobilely to your CRMLS mobile app. But it happens way too often that people go live with a listing and they have no photos in there. You need to get one photo of the exterior of the structure, a substantial portion, within 2 calendar days of going live. Okay, it doesn't have to be the front. It could be the back if that's the better looking part of the property. It could be, a little bit of an aerial shot. you got to have at least one photo on there that shows the potential buyer or tenant what they should be looking for when they drive up. All right. And just think real practically. If you were a consumer, first of all, if there's no photo, you're going to be disappointed. You're not going to really be interested, right? So that's a disservice to your seller or the landlord to not have photos in. And if you're a consumer, you're like, well, I want to know what it's like, so I go to the right place, right? Or something along those lines. We give you 2 days to get one photo in. For some reason, this is very challenging. And we issue a lot of citations. This one has no warning either, and it's a $250 fine. If you cancel your listing within 2 days of entry, you don't need the photo. If you sell it within 2 days, you've got to get a photo in as well. So pretty much in every circumstance, unless it's a business opportunity listing, you have to have that photo in. Make sense? All right. Now, the substantial portion of the exterior of the property. Again, this picture you see on the screen, beautiful backyard. If that was your only exterior photo, that's fine, right? The consumer can say, well, I don't know what it looks like from the street, but I can see there's a big house here, and that's what I'm interested in. So it's legit, right? This is a legit piece of property. Now, on the other hand, what about these photos? Right? And this is the situation with condos a lot of time. You got 3-4 story condo building. The exterior photo gets submitted and it's the front door. Right? Well, that doesn't really tell me anything. It just tells me there's a door. At a minimum here, you'd want these photos to be back further. Show us the building, right? I mean, give me an understanding of where this place is at. Just think practically. If you're the consumer, would this be helpful to you? Definitely not. Okay. So one photo within 2 days, even if it's a land listing, even if it's far away, even if it's gross and there's construction going on, it's still, there's no excuse. You're still going to get a citation if you don't have the compliant photo in. Now, an afterthought on this. We get a lot of requests for removal of photos after a closing. People come to us all the time and say, hey, I own this house now and I have a right of privacy, so I want you to take all these photos down. The answer is no. We are not going to do that. Number one, there is no such legal right. You do not have the right to have information taken down that was the property of the previous broker. Okay? If you guys are familiar with your RPA form, go look at paragraph 21. It literally says, buyer acknowledges that MLS photos will not be removed after closing. Okay? Thank you, CAR. We don't have to do it. In fact, we're required by California Civil Code 1088 to have all of our historical information in our system and available for at least 3 years. And even after 3 years, we're probably not going to do it because we don't have to. Right? There is no legal right claim here. You could get a court order, like if there's a restraining order, we're going to listen to that, of course. We'll do that. But, we get requests like, well, this is my house, right? And I don't like this being out there. Well, that's just kind of how it goes. Now, the good news is you can have the listing broker go in and click no internet on that closed listing. At that point, CRMLS will not send the information out to syndication sites or websites. So the only place that the photos can be seen will be in the MLS. So there is an answer there. A lot of people will go in and just remove all the photos before closing. Okay, we can't stop you from doing that. It's not great. It doesn't help appraisers or anybody else doing, CMAs. But some people do this and they take all the photos and they don't even leave one exterior photo, right? And they end up getting a citation. So that's it. That's the final word on photos. Again, content, review your content. Make sure what you have in there, there's nothing impermissible. Number two, permission. If you didn't take the photos, figure out who did. And guys, that's even counts if your seller gives them to you. Don't just take your seller's word for it. Say, ask them, where'd you get these photos? We get that happen a lot. Well, the seller gave them to me. Well, your seller stole them off of Zillow, right? I mean, this happens. So be careful, get permission. And then have at least one photo in within 2 days of the exterior of the structure, and you will be fine if you do all these things or don't do all these things with respect to photos. Moving on, the second most popular rule violation is inaccurate information. This could cover anything in the listing, right? So the broker is responsible to put information in the MLS that is accurate to the best of their knowledge. And obviously you want it to be right, okay? You're good at your job. You're going to know about this property. You're going to put the right information in there. But sometimes stuff's wrong bedroom count, etc. It's not a private pool. It's a community pool. I mean, it could be anything in the listing could be inaccurate. Now, the good news with this is when we get these reports, this comes with a warning. All right, we'll reach out to you and give you 2 days to fix it. And the vast majority of these get reported, that get reported are corrected before a fine is ever issued. So just be accurate, right? That's not too much to ask. And if ultimately though, if you don't fix it, we will remove the information and you'll get a citation. Okay, so pay attention. It's not that hard. The next one on our list is public remarks. So this is obviously sometimes called the property description field. And I want you to think of that property description field the same way you think as photos. Neutral. Okay, this description should only be about what's being sold or offered for lease. It is not a place for you to communicate a bunch of other stuff, right? Things like security information, showing instructions. There's already a field for that. Compensation, you probably know very well that you can't say anything about that now. I sure hope you do. You don't put the lockbox info in there. You don't tell people that it's vacant. You don't put your own email. You don't solicit. You don't say, call Jeff at 714 blah, blah, blah for a private showing. That's branding. Treat it like a photo. Neutral. Neutral. No marketing, promotion, inappropriate content. Just tell the folks out there what's great about this property. Okay, and then also fair housing guidelines, which thankfully we hardly ever see people say inappropriate things to that extent. Public remarks, property description, keep it neutral. And also, don't borrow it. This happens too. People love the description of the property that the previous listing broker used, and they just copy and paste it. And lo and behold, that listing broker sees it and says, hey, that's mine. Well, you can get a citation for that under Rule 12.5. Questions on that? Pretty straightforward, right? Next is failure to correct a violation. So this one is completely avoidable because it only happens after you've already gotten a citation. Okay, so our purpose is not just to send citations, it's to keep the data accurate. And so if you get a citation for something that's wrong with your listing, our hope and goal ultimately is that you would fix it. We'll give you some time to fix it. But if you don't fix it, we want it fixed so bad that we will send you another citation. So instead of one, which provides instructions, right? The first citation will tell you exactly how to correct it. People ignore that, run off and, they're upset or whatever, and they get even more upset because they didn't fix what was supposed to be corrected, and they get another citation under Rule 14.4. This is entirely avoidable. All of these rules that I just gone over, super straightforward, okay? Photo stuff, pretty straightforward and clear. Inaccurate information, public remarks, failure to correct, all pretty straightforward. So any questions on the failure to correct? Okay, well, those are the most popular violations, right? The most common. I'll go back to the beginning and show you that list again. Sorry. There it is. Again, photos, media, and copyright issues. No exterior photo. Inaccurate information. Don't worry about that auto sold. Misuse of public remarks and failure to correct. 75 to 80% of the citations we issue in an annual basis are under these 5 categories. Again, they're pretty straightforward. If you guys can simply remember this stuff that I've told you today, you will not step in it. All right, so let's move on to, I do want to cover clear cooperation real briefly. If you are familiar with clear cooperation, you should be, or if you're not, you should be. The clear cooperation policy had to do with, the private listings kept off the MLS by brokers who are members of an MLS. This was over 5 years ago that NAR came out with the Clear Cooperation Policy 8.0 and made it mandatory. So as of May 1st in 2020, it became a new mandatory rule that if you have a listing subject to a exclusive or seller reserved listing agreement and you have not put it in the MLS yet for cooperation, that means under active or coming soon, and then you go ahead and you publicly market that listing, you will now have triggered a clock, a 1 business day clock. By the end of that business day, you had better have that listing in the MLS or you could be getting a big hefty fine. Okay, so what are the questions that are relevant here? Well, what is public marketing or who is the public and what is marketing? So let's say I have a listing, I haven't put it in the MLS yet. What can I and can I not do if I want to avoid publicly marketing the listing? Or I'm sorry, marketing the listing. Well, guys, any sharing really, I don't need to tell you guys what marketing is. It's basically any communication that is designed to elicit some kind of interest in that property. Signs, websites, social media, brokerage, franchise operated websites, any communications, verbal or written, meetings, networks, flyers, open houses. If you have a listing, it's not in the MLS yet, and you do any of these things, you have marketed the property. So if you have a listing, you haven't put it in the MLS yet, the sign company comes out, puts up your sign. An agent drives by or a consumer, tries to find that listing in the MLS, can't find it, they can report that to us and we will reach out to you and figure out what's going on. All right, so you have to act within 1 business day of any of this stuff occurring. Now, second question is, who is the public? Well, the public is anybody other than the group that's defined on this slide. The only people who are not the public are consumer clients of your brokerage who have signed an AD form with your broker in the last year, or any of the other agents under the same broker as you. So that basically creates what we call the office exclusive exemption. So if you have a listing, you haven't put in the MLS yet, you're in your brokerage office only, and you want to share it with the fellow agents under the same broker as you, you can do that. Or with any of your clients out there who've signed an AD form with the broker in the last year. So there are people you can talk to about the listing, but if you go outside that circle, you have publicly marketed it as long as it constitutes marketing. So that's CCP, Clear Cooperation Policy. If you've paid attention lately to anything out there in the world of real estate, you know that this continues to be something that's discussed widely. There are a lot of stakeholders in the industry who don't like it and some that really like it. And CRMLS has no real take on it other than to say that we really do think this is the best policy for consumers and for the marketplace. We really don't believe that hiding listings and marketing them only to a select few is what's best for competition in the marketplace and for consumers. It can lead to very specific targeting of who you market to. We don't like the way that the data, if you have listings that are sold off the MLS, then that sales data is not available to anybody. There's a lot of problems with it. There's a lot of, and then there's the arguments that, oh, it's about privacy. Well, you can still have privacy. Okay. You don't need to put up signs. You can put it in the MLS and click no internet, and it will not go outside of the MLS. The only people who will see it will be other agents who happen to cross it in the MLS. And what harm can that be, right? So it is what it is at this point. It's still going to be controversial. CRMLS is a staunch supporter of the CCP. In recent weeks and months, some things have come down from NAR, but at this point, we have not changed a single thing since we started this 5 years ago. We are not doing anything different. CCP is still the law of the land in terms of mandatory MLS policies, and so we are continuing to enforce it. Any questions on clear cooperation? Any questions at all on compliance stuff? Questions on anything in the news? Questions on anything in the industry? Anything about the MLS? Okay. Well, I'm going to give you a lot of your day back, although let me see. I got a chat question that popped up. Marion asks, what if the agent is the owner of the home and is going to market it in social media as a homeowner prior to listing it? So a FSBO is not subject to an exclusive listing agreement, so clear cooperation doesn't apply. Okay. The only properties that clear cooperation apply to are those that are under a listing agreement. If you market something and you don't have a listing agreement with the seller, I mean, that's on you, right? Because there's a lot of risk involved. But for good or bad, we can't enforce CCP against you because there is no listing agreement. It doesn't come into effect yet. So if this hypothetical, if the seller is the homeowner, is also an agent and just wants to throw it out there as a FSBO, that's fine, right? I mean, we can't stop that. But at some point, you're going to get, you're going to get a listing agreement put in place and things will change. Mylene has a question. In public remarks, are we allowed to offer a 2-1 buy down, such as seller offering to pay for a 2-1 buy down? Yes. So that's a great question. Okay, we consider something like that to be part of the marketing and appeal of the property listing. All right. We just ask that it not be branded. So in other words, we're working with ABC Lending to offer this. You can't do that. But if you also want to put something like seller is offering seller financing, right? Seller willing to rent back. I mean, these are things that a consumer would be interested in. All right. And if you keep it unbranded, you can do that kind of thing. If you ever have a question, guys, about your photos or your public remarks before you publish them, come into the chat, the CRMLS chat, and just ask one of my analysts. Just copy and paste what you think you're going to put in there, and then we'll tell you, thumbs up or thumbs down. All right. Let's see. More questions coming in. Good. Crystal asks, what if photos are of a turnkey property, but the property in person is actually completely dilapidated? Great question. So we have a rule that would cover this. It's Rule 12.10, and it has to do with truth in media. Okay, it's sort of the equivalent of a false advertising rule from an MLS perspective. If it completely misrepresents what's there, this would be a citable offense. So you would report that to us. We would need some evidence, right? So if you report this listing to us and say, hey, this place is a disaster, there's no roof, and the photos say there is one, well, we can look at the listing and see the photos, but you would need to send us a photo of what's going on at this property so we can prove it. Okay, great question. Yes, that's a problem. Lori asks, do you have to acknowledge if you use virtual staging? We strongly recommend it because, again, that's truthful. There's no harm in it, right? You want to be transparent in your listing and be accurate. Now, I will tell you this. The Rules Committee and the Board of Directors has recently approved a rule change requiring this disclosure of virtual staging. It just hasn't been published yet. So in a couple of months, we're going to publish a new rule set, and that will be a rule. So at that point, the answer to your question, Lori, will be yes, 100%. Zariah asks, could you explain again how it can be in the MLS but not the internet? Yes. So this is a very simple thing for the listing broker to choose if they want to keep the listing only in the MLS and not send it out via our data feeds to other agents' websites or big broker portals like Zillow or homes.com or realtor.com. If you click no internet, and it's right there when you're uploading your listing, and you can actually do it later as well. If you go in and edit your listing and there's a button in there that says you can select no internet distribution, once you do that, no information will flow out from the MLS and populate out there in the world. Okay, it's a simple switch, pretty straightforward. Susan asks, are we allowed to put labels on photos like main house or guest house or living room or family room? Yes, 100%. Your system, your front end MLS system should have a caption field under any photo, and you can describe those photos as you see fit, as long as it's not like inappropriate. And Crystal says, thank you. So I don't see any more questions coming through. I'm going to stop my share. Well, actually, no, we already did this. If you need to talk to us, you can email us at compliance at crmls.org. Sorry. We also have chat. Okay. Chat hours are 8:30 to 4, Monday through Friday. You can go in there and ask my analyst anything. They're live people, not robots. You can ask them, hey, what do you think of this photo? What do you think of these public remarks? Hey, I saw this happen out there in the world. What do you think about that? Right? We can talk to you about any of that other stuff. If you are a broker, CRMLS Compliance actually has a dedicated broker helpline as well. And so we can get you that number if you're looking. That number's on our website as well. So we're busy always, but we would love to be less busy issuing citations. And that is the point of what we do in these education. That's why I like Shirley inviting me down to talk to you guys. You ask good questions. I'm giving you the basics, the most popular common violations that are super easy to avoid. And, Godspeed. I hope you guys go out there and make millions of dollars and you never have to ever talk to compliance in a negative way. And I hope that this presentation webinar was part of that and that it was helpful. Okay, well, 10:47, so I'm going to give you back, a little bit of your day, and I appreciate you guys very much. And Shirley, thank you for everything. And that will wrap it up for me.